Ladies and gentlemen, welcome to Civil Justice Subcommittee for March the 5th, 2025. Madam Clerk, take the roll. Madam Clerk, take the roll.
Mr. Chairman, you have 5 members present. You have a quorum.
Thank you. Members, do we have any personal orders this afternoon? Any personal orders? Seeing none, we'll jump right in the calendar. Without objection, item number 5, HJR number 7, rolled 1 week. Without objection, item number 6, House Bill 571, rolled 2 weeks. Brings us to item number 2, House Bill 755. Do I have a motion? We got a second? We got a second. Representative Faison, you're recognized.
Thank you, Mr. Chair. Committee, certainly good to be with y'all. Hope you're well today. And Mr. Chair, there is an amendment to this bill. Do you want to put the amendment on and kind of explain what the bill does?
Yes, sir. What's the number you show?
003261.
That's what I got. I got a motion and a second. All in favor of adding 003261 to HB 755, signify by saying aye. Opposed, no. The ayes have it. Amendment added. You're recognized on the bills amended.
Thank you, Mr. Chair. Sometimes the best way to explain what a bill does is tell you a story of how the bill came to you. It came to me from a constituent. Last November, a tragic accident took one of my circuit court judges that I'm very close friends with. It was the end of August, and his widow called me in October and said, Jeremy, we never received payment from the AOC, Administrative Office of Courts, for my husband's last month, and he did work the whole month. Would you kind of find out what the problem is? So I reached out to the AOC, and unfortunately, this has happened several times with other people in the judiciary. Back in 1994, the legislature passed a bill, and really can't get to the history of why the bill was passed, but they put a cap on if your final check or if the check that you're due is over $10,000, that it goes to probate and doesn't go to your account. And so working with the AOC, they said, we would love it if you would fix this. I reached out to the NFIB. The NFIB was like, we support fixing that. Reached out to the Tennessee Chamber. Tennessee Chamber also said they support fixing it. So we can't really come up with a reason. If you've worked, the money deserves to go in that account. We can't come up with a reason to have any cap on it all. So we're just removing the $10,000 cap and not putting any future cap on it on this one.
Very good. Members, do we have any questions for the sponsor? Seeing none, we'll be voting on House Bill 755. All those in favor of sending House Bill 755 to full judiciary signify by voting aye. Those opposed vote no. Has all members voted? Does any members wish to change their vote? Madam Clerk, takes the vote.
Mr. Chairman, you have 7 ayes, 0 noes.
The ayes prevail.
Thank you, committee.
And it's to judiciary as amended. That brings us back to item number 1, House Bill 1340 by Chairman Farmer. Do I have a motion? We got a motion and a second. Chairman Farmer, you're recognized.
Thank you, Mr. Chair, and I apologize for being late. Members, we do have an individual from the Secretary of State's office here, but Connor's here just in case we want to hear from him. But this is legislation brought to us from the Secretary of State's office. This bill requires someone wanting to become an online notary to take an approved class about online notarizations and to pass a test before receiving an online notary commission or an online notary commission. This requirement would be important because online notarial laws, the technology used for online notarizations, and the ethical requirements for online notaries are different than those from a traditional notary. So, with that said, I apologize I don't have any more of a detailed explanation, but we want to hear if we have any questions or such, we do have someone here from the Secretary of State's office that can follow up with that.
The question has been called. All those in favor of sending House Bill 1340 to full judiciary signify by voting aye. All those opposed signify by voting no. Has all members voted? Does any members wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 8 ayes, 0 noes.
The ayes prevail. House Bill 1340, full judiciary. That brings us to item number 3, House Bill 762. We got a motion and a second. Chair Lady Littleton, you're recognized.
Thank you, Mr. Chairman and committee. This bill allows certified facility dogs to accompany victims and witnesses during court proceedings. Studies show that simply petting a dog can lower cortisol, a hormone associated with stress. Additionally, petting a dog can increase a hormone that promotes feelings of well-being and bonding. This enables victims and witnesses to deliver more accurate testimony, helping to ensure that justice is served. And this bill was brought to me by the DA's conference.
Very good. Members, we got some testimony, or do y'all wish to vote? Anybody wish to speak to the question has been called? Members, we're voting on House Bill 762 to send to full judiciary. All those in favor signify by voting aye. Those opposed vote no. As all members voted, does any member wish to change their vote? Madam Clerk, takes vote.
Mr. Chairman, you have 8 ayes, 0 noes.
The ayes prevail. 762 goes to full judiciary.
Thank you, Mr. Chairman and committee.
You're welcome. That brings us to item number 4, House Bill 4. By Representative Bolzo, we got a motion and a second. Representative, you're recognized.
Thank you, Mr. Chairman. I have an amendment I'd like to put on the bill.
What's the number you show?
004187.
That's what I show. Members, we got a motion and a second. We got a motion and a second. All those in favor of adding 04187 to House Bill 4 signify by saying aye. Opposed, no. The ayes prevail. Representative Bolzo, you're recognized as amended.
Thank you, Mr. Chairman. Good afternoon, members of the committee. Members, this bill raises a single question. Should a governmental entity carry adequate liability insurance to protect its citizens against injury? I think we can all agree that the answer to that question is yes. Governmental entities should carry adequate liability insurance to protect citizens against injuries. That has not always been the case in our history as a state. You know, prior to 1973, local governmental entities were immune from a suit even for negligent acts. But this body in 1973 actually partially removed that sovereign immunity when it enacted the Governmental Tort Liability Act. And initially, when this body enacted the GTLA, it set limits of insurance that local governments must carry at $40,000 per person, $80,000 per incident, and $20,000 for property damage. Now, over the years, of course, this body has raised those amounts as the effects of inflation and increases in cost of living have occurred. And that has continued up until 2007. In 2007, this body raised the limits of insurance that governmental entities are required to carry to $300,000 per person, $700,000 per incident, and then $100,000 for property damage. So it's now been 18 years since this body has gone back and adjusted these amounts, which I can point out is the longest period of time since this statute was adopted that the amounts have remained the same. And yet we know that cost of living has increased. And what this bill does is very simple. As amended, it simply seeks to increase the minimum insurance coverage that local governments must carry to account for the increases in cost of living from 2007 to the present. Specifically, when you look at 2007 to the present, inflation has occurred at a rate of 2.36% per year, and cumulatively that's over 50%. So the bill seeks to raise the $300,000 per person insurance limit to $400,000 this year, and then to $500,000 in 2027. Because when you gross up $300,000 in 2007 dollars to today, you get an amount slightly above $500,000. And then similarly, with regard to the amount in the aggregate, it seeks to raise the $700,000 minimum limit this year to $850,000 and then to $1 million in 2027, because once again, if you adjust the $700,000 figure from 2007 to the present for inflation, you get an amount that's slightly above $1 million. And then we seek to adjust property damage up to $200,000 for the same reason. Now, if I could anticipate one question, obviously that could be on the minds of many members, is there really a need to do this? Or are these amounts that we already have still sufficient? And I submit that the evidence that is before us shows that it definitely is necessary to increase the limits, because we have over 500 local governmental entities across the state. We have 147 school districts. We've got 95 counties. We've got over 300 municipalities. Let me just focus on the school districts, so the 147 school districts, because this is where we see this occurring quite a bit. Because we do have, regrettably, school bus accidents every year. And I asked the Department of Safety and Homeland Security to go back and give us the data on just school bus crashes for the last 10 years. And what the data showed was that from 2015 to 2024, we had 24 fatalities in school bus collisions. And as the statute stands right now, if a parent loses a child in a school bus crash, the amount that parents could recover is capped under the statute right now at $300,000, which I think we can all agree is not adequate compensation for the loss of a child. Also, the data shows that there were 124 serious injuries in the last 10 years in school bus crashes from 2015 to 2024. And then we've got possible injuries of over 1,029 over the last 10 years. And some of you, I know from speaking with you, are aware of these collisions because some of them occurred in your districts. I'm aware of one in particular that occurred here in Nashville just a few years ago. We had a bus from Chester County Schools where the bus driver was rounded.
Representative Bolzo, that's your 5 minutes, but a very good explanation of the bill. So members, we have any questions for the sponsor? And Representative Garrett, you was first, and then Representative Johnson.
Thank you. Thank you, Mr. Chairman. I appreciate it. But I just wanted you to be able to finish your thoughts there on the bus, because I think that's an important statistic regarding this. So if you would just finish your thought on that particular position on the bus crash, I would
Representative Bolzo,
appreciate
you
it.
recognize.
Thank you, Mr. Chairman. I'm happy to. Representative Garrett, what occurred is that the bus driver took an off-ramp of I-40 too quickly and the bus overturned. There were 20 to 30 students on the bus at the time, many of whom suffered broken bones, several of whom had medical expenses that on their own were in the six figures. And the court ultimately had to appoint a special master to determine how the families of those 20 to 30 children would divide the $700,000 cap. So that is just an example of what we see from the data from the Department of Safety that makes it clear that we need to keep up with moving these caps, not aggressively. This is very conservative. We're just moving them to account for the increased cost of living from 2007 to the present.
Representative Garrett, you got follow-up? Representative Johnson?
Thank you. I don't know if it's so much a question, but I think this is important because I have a constituent who was hit by a bus, not a school bus, but hit by a bus and lost both of her legs just at the knee and was awarded $300,000. Almost half of that went to the hospital. And so that's very little for a younger woman who's got a career ahead of her and right now can't get a decent wheelchair. And it's very, very frustrating. So.
Representative Bolzo?
Thank you, Mr. Chairman. Exactly, Representative Johnson. And that is the type of injury that this bill is designed to address. It's not going to address it in full, but it will address it in a way that at least keeps these amounts current with costs, with increases in the cost of inflation.
Representative Johnson? Any follow-up? Members, I don't see anybody else on the list. We'll be Representative Todd, you recognize.
Thank you, Mr. Chairman. I just would like to, state for the record that, I've had a lot of input from small businesses across the state, from even some of my locals, obviously, that are affected by this. And it seems like they're opposed to any increase whatsoever. And I can't disagree with your arguments here, but I know it's going to potentially cost them more money. I mean, any kind of increase in limits is going to cost them a higher premium, and therefore the taxpayers are going to bear that. And so for that reason, I'm going to have to be a no. But I do appreciate the effort, and I understand the purpose here. And I know you've been very responsive to questions that many of us have asked. You've also been very reasonable to back away from the original numbers in the bill and work on something very calculated. And so I do appreciate that.
Representative Bowles, can I follow up?
Thank you, Mr. Chairman. Yes, I can offer 2 points in reference to Chairman Todd's comments. First, businesses do have concerns, as obviously some of the insurance companies and some of the insurance pools do. One thing I learned from discussing this bill with various constituencies is that one of our insurance pools in Tennessee here, Public Entity Partners, PEP, actually already has in its policies $1 million in catastrophic coverage for medical expenses. So that is an example of an insurance pool, in my view, acting responsibly. It has recognized that these limits are too low, and so it is already charging an additional premium to its clients in order to provide adequate coverage to citizens. So I think that by itself is an indication that it's time to move the limits, because we have one of the insurance pools already having done that. And then secondly, I think that to the extent that some cities or counties are complaining about the cost of the increase of premiums, bear this in mind, that Governmental Tort Liability Act only relates to negligence claims under state law, most of which are automotive in nature. But there are other types of claims that are routinely brought against local governments, including for acts of police officers or sheriff's deputies. And typically those claims are brought in federal court under a statute called 42 U.S.C. Section 1983, the Federal Civil Rights Act. And there is no cap whatsoever on the exposure that local governments have for what's called a Section 1983 action. And so our local governments are already paying additional premiums for limits of $1 million and sometimes more to cover that type of liability. They're also paying increased premiums for additional limits for claims like employment harassment, employment discrimination, which also arise under federal law and are therefore not subject to any cap. So although I've heard some of the same concerns, Chairman Todd, I do not believe that they've been demonstrated. I believe to a certain extent they've been exaggerated, but regardless, in my view, our duty is to our constituents, real live individuals who are at risk of not being adequately compensated unless we continue to keep these limits up with the cost of living increases.
Representative Todd, you recognize? Representative Senate.
Thank you, Chairman. First thing is, Representative, thank you for going back and amending it, because it's helped me a little bit in my district. My district, everyone I've spoken to is negative. But I guess my question to you is, let's go back to your bus situation. A 16-year-old who permanently gets injured and can never have the ability to work and make a living, what would it cost to finance that child for the rest of his life?
Representative Bowles.
Thank you, Mr. Chairman. A lot. I mean, if you're considering a catastrophic injury of that nature, Representative Stinnett, obviously even the $500,000 that I'm seeking to move the limits to does not even remotely cover it. And when you consider the loss of earning capacity, which in many cases is the most significant part of a damage award in a negligence action, obviously you're running into the millions of dollars.
Representative Stinnett.
Thank you, Chairman. So I'm going to support this, because we do have accidents where people get hurt and cannot go back to work. And we need to make sure that we at least try to sustain them for part of their life. Thank you, sir.
Representative Bowles, any follow-up?
Nothing further, Mr. Chairman.
Okay, I don't show anybody else on the list. I do have a question. In 2007, when this was last voted in, what is $300,000 in today's money if you had to change it to inflation, for inflation?
It is approximately $549,000. let me. I was slightly off, Mr. Chairman. It's $470,819.
Perfect. Thank you. Members, we're voting on House Bill 4 to send it to full judiciary. All those in favor signify by voting aye. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 5 ayes, 2 nays, 1 present not voting.
House Bill 4, the ayes prevail. Goes to full judiciary as amended.
Thank you, Mr. Chairman. Thank you, committee.
Thank you. That brings us to item number 7, House Bill 745 by Representative Stevens. Do I have a motion? Got a motion and a second. And Representative Stevens, I do show an amendment.
That is correct. It's 3889.
That's what I show. Members, we want to add 03889. We got a motion and a second. All those in favor signify by saying aye. Opposed, no. Amendment added. Representative Stevens, you are recognized on 745 as amended.
Thank you, Mr. Chairman. This bill deals with banking. It does 2 things. The first one is it extends the amount of time that a bank has to respond to a garnishment order to 2 business days from the current 1 business day. And second, it allows a prevailing bank to recover attorney's fees and actions for check fraud claims under the UCC.
Thank you. Members, this is pretty straightforward. We do have testimony if you'd like to hear it, or we can vote. Do I hear a motion to go out of session? Do I have a motion to? Question has been called. Members, we're voting on House Bill 745. All those in favor of sending it to the full judiciary signify by voting aye. Opposed, no. As long as we get it up there, Representative Davis. Has every member voted? Does any member wish to change their vote? Madam Clerk, takes a vote.
Mr. Chairman, you have 8 ayes, 0 noes.
The ayes prevail. House Bill 745, full judiciary as amended. Congratulations. That brings us to item number 8, House Bill 1012 by Representative Shaw. We got a motion and a second. Representative Shaw, you are recognized, and I do not show any amendments.
Thank you, Mr. Chairman and members. It's good to be here today, and I really wished I had a story to tell you as Chairman Faison did. However, I do not. This comes from one of our constituents back home, and what the bill seeks to do, it seeks to establish some conduct that I feel like that's already in the law against an attorney who would commit perjury. It's what the bill seems to do. It says that anyone establishing as an attorney who, while acting in the capacity of counsel for a client or an identified prospective client, engage in any conduct such as perjury, aggravated perjury, subordination perjury, tampering with evidence and so forth and so on would be punished as the law already requires to be punished. And I think I spoke to Chairman Garrett about this, and he was sharing with me that this is already in code, but I'm here because of my constituent who wanted me to bring this bill to see if we could get some teeth put in the law concerning this. So I'm at the will of any questions that anyone may have.
Thank you, Representative Shaw. And first on my list is Representative Garrett.
Thank you, Mr. Chairman. Representative Shaw, thank you for bringing this legislation. And also thank you for giving me a heads up and letting me know kind of what was going on. And the way that I understand the piece of legislation is that if a lawyer should act in any of the ways, the examples that you had said, including perjury or conduct unbecoming of a lawyer, I believe the way the bill is drafted might give them immunity. And I just want to make sure that you are aware, and if your constituent is listening, there is no immunity for a lawyer to act in any way that the regular citizen shouldn't. It's a non-lawyer, right? We don't have any elevated or unqualified or even qualified immunity acting on behalf of one of our clients. And as I don't know, just for your constituents' purposes, I do practice law in the state of Tennessee. Been practicing for now 17 or 18 years, and there are even rules in place for me as a lawyer. If I disagree with my client, there's certain ethics rules that I must declare to the judge, that I must withdraw from that particular matter if there are competing views on how our particular case should go forward. And so if I had acted as a lawyer in any of the ways that your piece of legislation exists, not only could I be prosecuted to the extent of the law, but I also would lose my license to be able to practice law. So I'd get double whammied, so to speak. Not only would I be going to jail for perjury, just like me or you or Representative Johnson or whoever else is in this room for perjuring themselves in a court of law, that is a crime. And it's no different if it's you making it or if it's a lawyer making it. So I do appreciate that you brought this legislation and brought the attention to this, but I want to be absolutely clear that there is no immunity provided to a lawyer under what the bill tries to address. Those are already crimes. And on top of that, if I committed one of those, not only would I be in the pokey, but I would also not able to practice law whatsoever because I would be disbarred for conduct like that. So with that, I don't believe, since it's already, that I could support the piece of legislation. But I just want you to understand, for your constituent purposes, that we can't act like this as lawyers. So I appreciate that.
Representative Shaw, you recognize.
Thank you, Mr. Chairman. First of all, as a lawyer, don't sue me for this, okay? But number two, it's one of my clients, and certainly we try to accommodate our clients. And I think that there was some situation, and I do not know the full evidence of the full situation of what happened in a court case where maybe someone felt like perjury was committed or whatever. I do not have the answer to that, but I really appreciate the committee listening to me on this bill. And certainly if you can offer any advice to me other than what you have already offered, I would appreciate it very much.
Representative Garrett, you got to follow up.
Representative Shaw, I mean, it could be possible if you would be willing to roll the bill. I wouldn't mind having further conversations with you to see what we can do to maybe strengthen or do something that might satisfy your folks back home or whatnot. If you'd be willing to do that, I'd be willing to have that conversation with you and see what we can do about this particular piece of legislation if you're willing to do that.
Representative Shaw.
I would be, certainly. If I could ask the chairman and committee to give maybe it's a 2-week roll to 4 out.
That's very good. That would work perfect. So,
Okay.
members, without objection, we'll roll House Bill 1012, 2 weeks.
Thank you, Mr. Chairman, committee.
Thank you, Representative Shaw. Members, that brings us to item number 9, House Bill 491 by Chairman Farmer. We got a motion and a second, and I do show an amendment, Chairman. Would you like to go with that?
Yes, I would.
And what number do you show?
I have 3999.
Members, do we want to add 03999? We got a motion and a second. All those in favor of adding 3999 to House Bill 491 signify by saying aye. Opposed, no. The ayes prevail. Chairman Farmer, you're recognized on 491 as amended.
Thank you, Mr. Chair. Members, back in 2021, we set up the Opioid Abatement Council. That council was set up to collect the funds that were garnered from the settlements from the multiple pharmaceutical companies that helped cause our opioid crisis across our state and country. All this bill does, we're going to open up the code and allow for settlements from the Sackler family and Purdue in the amount of $90 million and accept an additional $15 million from the others that are already in the bill, McKesson Corporation, Johnson & Johnson, et cetera. So members, all we're doing is open up the code section to accept these monies to enter into the Opioid Abatement Council, in which will be distributed per the current law. With that, I renew my motion.
Very good explanation. Question's been called. Members, we're voting to send House Bill 491 to full judiciary. All those in favor signify by voting aye. Those opposed vote no. Has every member voted? Does any member wish to change their vote? Madam Clerk, takes a vote.
Mr. Chairman, you have 7 ayes, 0 noes.
The ayes prevail. House Bill 491 goes to full judiciary as amended. All right, members, that brings us to the end of the calendar. I'd like to thank each and every one of you for another great day of Civil Justice Subcommittee. Without objection, we're adjourned.